And court-martials, you would think that we'd have equal access to witnesses. And under the UCMJ, under the rules for court-martial, it says that we have equal access to witnesses, but the reality of that is completely different. The government really has an unlimited budget. When I say they have an unlimited budget, they have an unlimited budget to prosecute you. So if they want to call 10, 15 witnesses in the case against you, they can. And they don't need to ask anyone's permission. They just list them on a witness list, and they'll do subpoenas and compel them, and they can get whoever the hell they want to testify against you. If they want expert witnesses, a toxicologist, a forensic psych, someone in DNA, all they have to do is subpoena them and contract them to write the check. They have an unlimited budget. But in the military, as the defense team, we don't have an unlimited budget, and we don't have the ability to get anyone we want to. So the process is just insanity. And there may be some changes to this coming up with the NDAA, which I'm hoping solve some of these issues, but we'll see. But as it stands now, we actually have to draft the witnesses we want produced and ask the government for these witnesses. The government, the prosecutors, the same people that are prosecuting you, are the ones that get to approve what witnesses you're going to call. And that, it just sounds insane, but it's true. And so if you want witnesses in your defense, you have to draft a written request, list who that witness is, what they were going to testify to, why they're relevant and why they're necessary, and then submit that to the prosecutor so the prosecutor can then approve or deny that request. And this is what's happened now is almost gamesmanship. And so most cases now, they just deny every witness. I mean, I've got a case right now that's pending where we submitted 13 witnesses in our defense, and they just denied every single one, literally denied every single witness. And so now the prosecution has all the witnesses they want, and we get none. And so what then has to happen, we have to file a motion. We have to go do a written pleading to a military judge and go into court and have the judge compel the witnesses for our case. So at each level we're doing this, you're giving up a lot of your strategy. You're giving up really your case to the government. And you're putting it now, it's the military judge who oftentimes is a pocket prosecutor. Not all of them, but a lot of military judges are very prosecution friendly. Not all of them, but many of them are. And they're the ones who grant or deny the witnesses. And oftentimes they'll say witnesses are cumulative, or let's say you have a complainant, an alleged victim, and you've got 4 Marines that say, hey, she's a liar. She has a reputation for untruthfulness. And that's important testimony. We want to call Marines to say that the alleged victim is a liar. Well, if I have 4 different Marines, usually a judge will give us one and say, well, the other ones are cumulative. And yeah, maybe they're cumulative. I disagree with that, because one person can have an opinion, but if you're corroborated by 4 different Marines all say she's a liar, it's a lot more powerful to a jury. And so that really is the process. You have to make a request to the government. They typically deny all the witnesses. Then we have to go to court and actually litigate this, and the judge will grant or deny them. And it's a similar process for experts, although it's a little bit more complicated. Now, the real issue I see is that let's say you have a brand new military defense counsel from the ADC's office or the trial defense or the DSO, there is a real strategy that's involved in getting witnesses. You'd think it'd be easy. And again, I've been arguing for a decade that the defense team should have their own pot of money to get witnesses. And that, again, there may be some changes to that coming up with the new NDAA, but right now it's not in place. There is real strategy you have to use in terms of how you draft the written requests, what those need to include, what they need to not say. Oftentimes, it's not as important as what they say, but what's not said in these written requests, and then how to actually litigate these in front of a judge. Because if you have a very inexperienced lawyer that is doing this and doesn't have a lot of experience with getting witnesses, what will happen is you'll end up at your trial and you'll have needed 10 or 12 witnesses to prove your case, and you'll have 3. You say, well, how the hell do I only have 3 of the 10 witnesses we needed, or 3 of the 13 witnesses we needed? It's because you had a very new defense attorney who doesn't know how to play the game and win that game of getting witnesses. And they may be a brilliant litigator in court, but if you don't have the witnesses you need, you're screwed from the beginning. So that's really important to understand that process for actually knowing how to get the witnesses that you need.